executive institutions and our legislative institutions and our constitutional commissions as defenders of our Constitution. We are now left with only one institution, this judiciary. I don't know where that noise is from within here. I think if they are doing renovations, they may be told that this is so important a day for renovations. We may defer them to another day. And let's face it. Let's face it. The process of 18th October 2024 took 6 hours as a deliberate scheme to defeat each of the principles and values of good governance I have alluded to: transparency, accountability, procedural fairness, and public participation. Who did these violations? We are also here to call people to account. Who did it? Between the time we left Senate around midnight, between the time Senate closed business around midnight of 17th October 2024, and the time we woke up to the presidential communique of 18th October 2024, in that night, the Bishop Oginde-led Ethics and Anti-Corruption Commission is documented in the President's memorandum to have received, processed, and given a clearance to Honorable Kithure Kindiki. That night. My lords, history is important, and I may not remind you why our Constitution prescribes that our presidents be sworn in during the day. We were all adults, we know where that comes from. It's one of the most autochthonous provisions of our Constitution. And therefore, when things happen in the night, we have reason to have our antennas high. Between the time Senate rose on the night of 17th October 2024 and the time we woke up in the morning of 18th October 2024 to the President's communication to the National Assembly, we were told that the IEBC, which we now know is not properly constituted, has no commissioners, had purportedly cleared Honorable Kithure Kindiki in the night. I will not say much about KRA because I think KRA can work overnight and we will not complain. But it was that memorandum. The other culprit was the President himself. The President of the Republic of Kenya undertook these clearances overnight and in the morning had a clear, proofread memorandum. Exceptional efficiency, we celebrate that. To Parliament. Then the National Assembly itself. Now this is curious. The National Assembly itself had called a sitting prior to the resolution of the Senate. The sitting was called prior to the resolution of the Senate. To sit on a day, ordinarily not a day of sitting of the National Assembly, to process a resolution of Senate it had anticipated, the removal of a deputy president from office, and processing clearance or approval of another deputy president. We sit here as judges, we sit here as court assistants, we sit here as advocates representing various parties. I don't know who among us, once we take away the cloaks of the official roles we play, was proud as a Kenyan. observing these events as they happened. I don't know who among us was proud, now putting on the cloak of citizenship to watch these events unfold at that pace. Fortunately for us, my lords, my ladies, we have a judiciary of Honorable Richard Mwongo that arrested this process in its tracks to give the Constitution a chance to roar. In the far corners of Kerogoya. Fortunately for us, we have the judiciary of Honorable Chacha Mwita, His Lordship, that arrested this process to give the Constitution a chance. Today, you sit and I stand before the judiciary of Honorable Ike Ogola, Honorable Esim Rima, and Honorable Dr. Frida Mugambi, that has been invited by the respondents to undo that chance that the Honorable Mwita and the Honorable Mwongo gave the Constitution. We don't begrudge them for that invitation. Because under Article 48, they are entitled to come here and make that invitation. Our question is whether the judiciary of Honorable Ogola, Honorable Mrima, and Honorable Dr. Frida Mugambi will be baited by that invitation. That's our only question. Throughout these proceedings, we shall be looking at you in the eye to ask, will you fall for this bait or will you stand for the Constitution? Having laid out our broad attitudinal view of this matter, allow me to address you now on the law and the jurisprudence of conservatory orders. In terms of textual prescription, in terms of the prescription of text of the Constitution, we will find accommodation for conservatory orders in two aspects of Article 23, Clause 3 of the Constitution. Article 23, Clause 3 says, in any proceedings brought under Article 22, a court may grant appropriate relief. So we find accommodation of conservatory orders in the use of the phrase appropriate relief. Because appropriate relief is wide enough to accommodate anything under the sun that is necessary to give effect to a right, fundamental freedom, or I dare say, any other provision of the Constitution. The second accommodation is in paragraph C of Clause 3 of Article 23, which says, in any proceedings brought under Article 22, a court may grant appropriate relief, including, say, a conservatory order, expressly. I'm a bearer of good news that in determining whether or not to grant conservatory, to confirm these conservatory orders, my lords, you need not look further than in the files before you. I'll demonstrate you shortly. Just by looking at the files before you, you will see why you must confirm these conservatory orders. Let me go there. Allow me to address the brief issue of your jurisdiction over this matter from the files before you. I would invite you, when you retire, to look at the ruling of your brother, Justice Mwita, of 15th October 2024 in petition number 550 of 2024. When you look at that ruling, I would invite you to look at page number 7 of that ruling. There is a paragraph 7. The way that ruling was processed was that each theme the judge addressed it by beginning with paragraph 1 to the last, then another theme, paragraph 1. So you'll see a lot of paragraphs 1, 2, 3, then it ends and we begin paragraph 1 again. So you look at the paragraph 7 at page 7 of that ruling of Chacha Mwita in petition number 550 of 2024. For the benefit of this court, for the benefit of everybody who is listening, Honorable Chacha Mwita said the following things at paragraph 7, that the petitioner also argues that constitutional imperatives in conducting public participation were not met. The claim falls within the scheme of Article 165(3), so that this court has jurisdiction to interrogate whether any of constitutional processes said to have been conducted under its authority met the constitutional threshold. The judge has already established that the argument on public participation raised by the petitioners falls within the jurisdiction of this court under Article 165, Clause 3. Then, paragraph 9 of that ruling on the same page. Justice Chacha Mwita holds, first he observes that the first respondent has pushed an argument that this court has no jurisdiction to hear a matter arising from impeachment of the president or deputy president on the basis of Article 165(3)(c). Then he reproduces the provisions of the article verbatim. I wouldn't want to regurgitate that because you'll read it. He proceeds now to argue that Article 165(3)(c) is in relation to the process of removing the president or deputy president from office on grounds of incapacity. This process is initiated for purposes of investigating the president or deputy president's physical or mental capacity to perform functions of that office. And here's the clincher. This is a distinct process from that of impeachment in Article 145 as read with Article 150. Article 163(c) excludes jurisdiction of this court over the process undertaken in accordance with Article 144 and not Article 145 as read with Article 150 of the Constitution. Honorable Chacha Mwita has made a finding that this court has jurisdiction over a matter or a process undertaken under Article 145 as read with Article 150 of the Constitution. If you turn to page 9 of that same ruling, of Justice Chacha Mwita of 15th October 2024 in petition number 550, page 9, you will find another paragraph 4. I think I explained why these paragraphs run back and forth. Paragraph 4, he says, I'll read paragraph 4 and 5, so for full effect. Paragraph 4, Article 145 lays down the procedure to be followed in cases of impeachment and the timelines for doing so, including affording the person an opportunity to be heard on the charges. I have considered the constitutional provisions on impeachment and read decisions from the Supreme Court and the Court of Appeal, which are binding on this court. These decisions have laid down the position that it is important to let the impeachment process run its course, after which the court would have a look at any complaints on violation of either the Constitution, the law, or fundamental rights, including processes. After which, the court would have a look at any complaints. He's again asserting the jurisdiction of this court at this stage. Then, I would also invite you to look at at page 10 of that same ruling. At that same ruling. And this is the clearest warning that Justice Chacha Mwita was sending to the National Executive and the National Legislative Institutions Parliament. At paragraph 9 on page 10, he observes, in other words, constitutional processes are not about dashing to the finishing line, which is what they were doing. It's not about that. They were being told what you are doing is child's play. And we are not here about child's play. We are here about the Constitution. He says they have constitutional imperatives that must be complied with. And if not, such infractions will not be out of reach of our Constitution. He completes by saying, where there is an allegation that fundamental imperatives in the Constitution have not been complied with, which is the allegation that you have before you, my lords, my lady, the affected person, my client, His Excellency Rigathi Gachagua, has recourse to court, and the court will have to determine whether the state organ complied with the Constitution or the law. Has recourse to court. I began by saying, we need not look further than in the files before you to assert that these orders have been confirmed, and I'm beginning by confronting the unfortunate allegation of lack of jurisdiction that has been filed on behalf of the person who was nominated to be the deputy president and who is supposed to uphold the Constitution. At paragraph 10, he gives the most enduring philosophical statement of page 10, paragraph 10, page 10. In that respect, our Constitution offers both hope and promise. Hope that the institutions it has established will comply with its fundamental principles. We now know that that was hope against hope. And promise that the Constitution is supreme, and any act or omission in contravention of the Constitution is invalid. In other words, it does not matter how far the process may have gone, since no action is beyond the reach of our Constitution. My lords, I want to speak the truth here. In the face of these pre-existing rulings in these files, you will hear arguments here of non-justiciability of this dispute, political question doctrines, things that have been fished in a cut and paste manner from old American jurisprudence into a transformative constitution of the 21st century. I mean, that's unfortunate. I am hoping that once I'm done with this, those who came to court carrying those arguments of political question doctrine, non-justiciability, will find favor in abandoning them to save us some time. At the same page 10, you'll find another paragraph 1. I tell you the judge was starting paragraph 1 at every new issue. He says, Article 2, Clause 4 of our Constitution is not only the hope, but also the promise of our Constitution that we must abide by constitutional dictates, for any act or omission in contravention of this Constitution is invalid. That's what the judge is telling us. When you look at at the files before you, my lords, you'll also find the ruling of your brother, Justice L.N. Mugambi, in petition number 522 of 2024, His Excellency Rigathi Gachagua versus the Speaker of the National Assembly and others. Another file that is before you. At page 9 of that ruling, you will find paragraph number 34. In that paragraph, the judge observes, and that was when he was delivering the ruling to send this file to the Chief Justice to empanel the three of you to sit. He says, Article 165, Clause 3, Paragraph B or D of the Constitution has been delineated by Article 165, Clause 4 as constituting areas from which substantial questions of law might arise to require composition of a bench. He then goes ahead and reproduces Article 165, Clause 3, B and D. He's saying, before he sends this file to the Chief Justice to empanel a bench, he must satisfy himself that the dispute in question falls within Article 165, Clause 3, Paragraph B or D. And he made the determination that the dispute falls within Paragraph 165, Clause 3, Article 165, Clause 3, Paragraph B and D, and send the file to the Chief Justice to empanel the three of you. The three of you are sitting on this bench on a finding that the court has jurisdiction. In the absence of that, the dispute would have been outside the ambit of Article 165(4) for empaneling of a bench. Then there is your own jurisprudence as this bench. "13 days ago, on 16th of October, 2024. 13 days ago, the three of you, my Lord Justice Ogola, my Lord Justice Mrima, my Lady Justice Frida Mugambi, delivered yourselves on this question of jurisdiction. In that ruling, in petition number 522, as consolidated now with the others, in that ruling that you delivered on 16th of October, at paragraph 83, you observed that at the moment, that was at that time, this court is being called upon to anticipate the outcome of a process yet to be completed. The application at this point is premature and anticipatory. In any event, should the petitioners not succeed before the Senate, they still have an opportunity to approach the courts. The applicants cannot therefore say they have no remedy." Now, I was asking myself as I prepared, I'm imagining you now telling us, no, you have no jurisdiction. Having told us this, my Lord, how will you look at each other? How will you look at us? You told us yourselves, go to Senate. Once you have finished, come here. Then we come here and you agree with my friend Dr. Mudomi Thiankolu, these are political questions and therefore we cannot deal with them. These matters are unjusticiable. How basic decency militates against at least the three of you, saying you have no jurisdiction. I respectfully submit, my lords, my lady. You observe that paragraph 85, that this court, and I was asking myself, what does the word "this court" mean? This court means two things. You said, this court has unfettered jurisdiction to check the constitutionality of the process at whatever stage. As such, we are certain that the petitioner's rights are currently well guarded and none of the petitioners stands to suffer any prejudice. You assured us that you have unfettered jurisdiction, that's what we used, jurisdiction, to check the process at whatever stage. I've said the word this court, I understood it to mean two things. One, to mean the High Court, because you are talking about this court. I don't think you had forgotten you are judges of the High Court. So that when somebody comes and says, we ought to have gone to the Supreme Court, they must also justify to you why you are using the words this court in this context. And number two, it means this bench. The three of you sitting here as a bench. You are now this court in this matter. You have unfettered jurisdiction to check the constitutionality of the process at whatever stage. At paragraph 87, you reiterated that you are exercising judicial restraint in order to accord constitutional entities the latitude to deal with their mandates. But then you said, we however clarify that courts can and ought to readily intervene in ongoing processes before any entity in the clearest of cases where there is evidence of flagrant and gross violation of human rights and fundamental freedoms. I began by telling you, the most flagrant is the happening of 18th of October 2024. The most undebatable. The National Assembly received a nomination of Honorable Kithure Kindiki from the President. The National Assembly had in its face Article 118 of the Constitution. In its face. I'm sure some members are sitting here of the National Assembly. They had in their face Article 118 of the Constitution. That article continued to pronounce itself because Article 259 says the law is always speaking. So this article was consistently speaking to the National Assembly. Consistently speaking that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. The law continuously spoke. The Speaker called the House Business Committee. They met. Article 118 was speaking to that committee that you shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. That committee turned a blind ear to this speech by the Constitution. They sat in plenary. Article 118 1B was speaking that you will facilitate public participation and involvement in the legislative and other business of Parliament and its committees. The plenary turned a deaf ear. 2, this dictate. The most blatant. I want to ask how we cannot stop the confirmation, the assumption of office of Honorable Kindiki on this argument only until we argue this matter fully and settle it at the hearing of the main petition. I want to see. I'm a career learner. If you convince me, I can tell my clients they have convinced me. But I'm trying to imagine the kind of philosophy you will require to convince me. The 50 million Kenyans out there know none of them was ever called upon to make any view, any thought on the suitability or otherwise of Honorable Kithure Kindiki to be the Deputy President of Kenya. They know. Then, at paragraph 90 of that ruling, you observed, in other words, this court is still able to grant a remedy even after the process in Parliament is concluded. You again asserted your jurisdiction. I want to conclude this aspect of my submissions, my lords, my ladies, by pointing out that it's a high time that we laughed out of this court anyone who questions the jurisdiction of this court in this matter in view of all these prior rulings in the files before you. allow me to then briefly address you on the other aspects of issuance of conservatory orders. Again, I will not go further than your own earlier rulings. In your ruling of 16th October 2024, at paragraphs 62 to 71, you pronounced yourselves on the principles that govern grant of conservatory orders. We agree with each of those principles that you set out in that ruling without any modification. We agree with each of the principles that you set out in paragraphs 61, sorry, my apologies, 62 all the way to 71. I will address myself to only one aspect of those principles and invite my learned colleague, Mr. Macharia, to address the remaining aspects. This is where you allude to the case of Gatirau Peter Munya versus Dixon Mwenda Githinji and two others. If I'm not mistaken, this must have been the matter that was argued by my colleague, Dr. Tiankolu, some times back, so he would know it very well. It was among the first cases to deal with this matter. It's actually the first one in the Supreme Court of Kenya. You see, we celebrate Dr. Mudhomi Tiankolu for contributing to this kind of jurisprudence. He observes, and I quote, that conservatory orders, consequently, should be granted on the inherent merits of a case, bearing in mind the public interest, caution of values, and the proportionate magnitudes and priority levels attributable to the relevant causes. I want to address myself to the inherent merit of this case and just on one aspect of public interest. In fact, let me just begin by putting aside the issue of public interest, by asserting as a principle, my lords, that I desire that you hold that the greatest public interest is upholding our Constitution. There can be no superior public interest attributable to politics or other considerations that would outweigh upholding our Constitution. In fact, that is my understanding of Articles 2 and Article 3 of the Constitution. Articles 2 and 3 of our Constitution provide that the greatest public interest is in upholding our Constitution. I can see my learned colleagues jittery. I don't know whether they want to raise an objection. Okay, thank you.
Not me. I would never raise an objection regarding you.
Thank you so much, my teacher and mentor, Professor Gedhu Muigai. And I'm sure our other colleagues have taken cue from you, Prof. So that, my lords, when a petitioner raises a matter like the clearest violation I have raised on what transpired on 18th, there can be no greater public interest than giving that matter a chance to be ventilated fully. I can't imagine of any. But having said that, let me now deal with how this petition meets the inherent merits test.
Just a minute. We had earlier on given a time allocation, which Mr. Kibe disagreed with and asked for 2 hours. We will give you that 2 hours and not beyond. You have done 1 hour.
Okay, let me now take 15 minutes to summarize the rest of the argument. Then we see how to wind up that. So let me address the issue of inherent merit, because that's my last argument. Then I can see what my learned colleague, Mr. Macharia, can mop up. We had got another indication, my lord, that we have the whole day. That's the last direction you gave before this one. So that's why your words, my lord. I'm sure the transcript will come out with those words.
That is, we speak as Africans.
Let me do the best I can in view of the new direction, because that has made me now to change my approach, which can...
Certainly, Mr. Ongoya, you didn't expect that we have the whole day. We had given directions on time,
Yes.
and on your own authority of Mr. Kibe, he said you would want 2 hours. And we have agreed to that. So let's stick to the petitioner's side having 2 hours.
Let me give it my best. We'll deal with the eventualities. Allow me then just to refer you to a few things. On your ruling of 16th October 2024, at paragraph 78, you observed, and I quote, "In sum, therefore, in determining whether a matter discloses a prima facie case, a court must look at the case as a whole. It must weigh, albeit preliminarily, the pleadings, the factual basis, the respective parties' positions, the remedies sought, and the law." Has been contravened or is threatened with contravention. Then you at paragraph 79, you observe, applying the above in this matter, petition 522 that is before you now, without much ado, we are satisfied that the consolidated petitions raise constitutional issues that require further judicial consideration. You made a finding that the case has inherent merit. You could see it without much ado. At paragraph 93 of that ruling of 16th of October, you observed that we have no doubt in our mind, your mind was clear, my lords, that this matter raises issues of immense public interest. A matter that raises issues of immense public interest, we argue, is a matter that is infused with inherent merit. When you consider the ruling of your brother, Justice Chacha Mwita, at page 9, paragraph 3, in petition number 550, which is now before you, the judge observes, and I quote, "There is further argument that constitutional imperatives on public participation were not complied with. The petitioner has given an example of Keio South constituency to demonstrate this fact. According to the public participation results for that constituency, the total number of people who participated is given as 43. Those who are in support are given as 70. Out of 43 participants in a public participation event to remove Gachagua, out of 43, 70 approved." Malo, that's the case before you. This is how we have treated His Excellency regarding Gachagua, my client. Those who did not support were 3. They also got those who did not support. Having gotten 70 out of 43, there has some residue of 3 not to support. The percentage of those who support was 162.79%. We used to distinguish law and mathematics by saying that mathematics gives us instruments of mathematical precision. I don't know what the National Assembly will do with this mathematics, but this is curious mathematics. The judge then observes, it is implausible that an attendance of 43 people would produce 70 people in support and 3 in opposition. I submit that there was no remedial measure to this blatant failure by the Senate. There was no remedial measure. This poison has worked with this dispute throughout the process up to the time we come here. I'm making out a case that this case has inherent merit by these findings. At page 11, the judge referred this matter to the Chief Justice to empanel a bench on finding that the issues raised in this petition were immense. Again, that speaks to the inherent merit. When you look at the ruling of Justice L.N. Mugambi of 11th October 2024, all the way from paragraph 38 to paragraph 42, the judge highlights the matters of grave significance that this petition raises as a precondition to referring this matter to the Chief Justice. I submit that this speaks to the inherent merit of this case. And finally, at least for my part, when you look at the order from Kerugoya in petition number E15 of 2024, which is before you, at order number 3, the judge observed that the matters raised in the petition being of great national importance and urgency. He then referred the file to the Chief Justice. And I have two observations to make here. The finding that the matter was of great national importance and urgency speaks to the inherent merit of this case. If you look at order number 5 of the order of your brother Justice Mwongo, he gave the conservatory order because of the finding in paragraph 3, in order 3. He says, in light of the nature of the matters raised as noted in order 3, a conservatory order be issued. I want to submit to the nature of those matters has never changed. For you to vacate this order, you must convince yourselves, convince us, and convince the entire Republic of Kenya that the nature of these matters has changed. The matter has remained as it was on 18th of October 2024, which was the basis for the grant of conservatory orders. I therefore submit as follows: that because this bench, Justice Mugambi, Justice Mwita, and Justice Mwongo have, in the various rulings above, already found that this matter has inherent merit, it is not open to the respondents in their application for setting aside to invite this very court to revisit that matter and reach a contrary finding in the face of the principle of res judicata that you considered and applied on 16th of this month. I also submit that because the 4 benches I have alluded to have consistently found that this court has jurisdiction, it is not open to the respondents to argue that this court has no jurisdiction and invite this court to enter a contrary view without violating the principle of res judicata that you used against the petitioners on 16th of October. I trust that my learned colleague, Mr. Macharia, has taken note of the time and therefore he is able to compress arguments so that we pave way to the other petitioners. I urge that you grant the conservatory orders in petition number 565 of 2024 and in petition number 15 of 2024 at Kerugoya to preserve the subject matter and to give these parties a chance to ventilate themselves on the merits in the main petition. Over to Mr. Macharia.
If it pleases your ladyship and my lord, I will speak to three issues. The first of those issues is an issue raised most robustly by my colleague, I believe it's Dr. Fiankolu, and it is the question of political question. The second issue, my lords and your ladyship, will be the question of fair hearing. And the third one will be jurisdiction in the context of Article 40. Let me begin with the last one. In response to what the petitioners will tell you this morning, you will be treated to the most astonishing claim in our 10 years of the Constitution 2010. You will be told that the National Assembly and the Senate and the Executive have a dictatorship, have an autocracy on political questions, that those questions cannot be questioned by this court. That is the textbook definition of dictatorship and autocracy. The Constitution of Kenya, beginning at Article 1 and going to Article 10 and on to the end, is replete with the word accountability. Kenya is not a presidential democracy. Kenya is not a legislative democracy. Kenya is a constitutional democracy. When we gave ourselves this constitution in 2010, we introduced into it a concept known as limited government. And what that concept means is that those who are accorded powers under the Constitution can only exercise those powers within the four corners of the power granted to them. That is number one. And that number two, on account of Articles 1, Article 2, and 3, all those decisions are amenable to judicial review for purposes of confirming compliance with the Constitution. My good friend, Mr. Dr. Fiankolu and his colleagues have in their submission cited to you a case which they have extracted from the Sonko, allow me to call it that, the Sonko Supreme Court decision. They tell you that on the basis of a decision called Nixon versus the United States, you have no jurisdiction on account of the political question doctrine. But what they've done actually is that they cut out the passages and left out the decision that the court actually made. This is what you will find at paragraph 113 of the Supreme Court decision. And so far, it's the only, I think, full decision by the Supreme Court on the question of impeachments. Full decision after an impeachment. This is what they say. In that sense, and and this is now a continuation from where the respondents here have cited in their submissions. In that sense, and in the exercise of these wide political powers, both the County Assembly and the Senate cannot act outside the confines of the Constitution. So that's the first point. The Senate and the National Assembly, even while acting politically, cannot act outside the confines of the Constitution and the law. That's number one. And they then say, and this is where you draw your jurisdiction from, for to do so would invariably invite the court's intervention, which is what we're asking you to do here today. They then cite the case of Nixon, which itself stated that there must be judicial review when state organs or state bodies misbehave. But this is what the court says. Courts are thus permitted to intervene where matters of constitutional violations arise. And that's not the only one, of course. We've cited before you other cases, including the Wambora decisions, where the court, both the Court of Appeal, went to great lengths to explain where you draw your jurisdiction from. So I believe the Supreme Court decision in the Sonko case should put to rest the question as to whether you have jurisdiction even on political questions. The respondents then make another submission. This is that this court lacks jurisdiction because jurisdiction to interrogate the presidency and its appointments or elections lies exclusively within the Supreme Court of Kenya. They don't say so explicitly, but they say so by way of example. And they tell you that under Article 164, I believe it is, Article 163, Sub-Article 3A, the exclusive original jurisdiction to hear and determine disputes relating to the elections to the office of the president arising under Article 140. It's important to linger on every of those words. The exclusive jurisdiction is limited to elections, number one, arising under Article 140. And there's a reason it's worded this way, and here's the reason. Now, not every election is a presidential election. Now, under the definitions set out under the Elections Act, the Elections Act is itself a statute promulgated by Parliament under the provisions of Article 82 of the Constitution of Kenya. It recognizes only 3 types of presidential elections. The first is Article 136. It is that election that leads and that has the qualifications and the mechanism for it under Article 138 that then leads to a petition in the Supreme Court of Kenya under Article 140. There is then another election under Article 139, Sub-Article 1B, and you'll find this in the definitions of the Elections Act. And the third presidential election understood is Article 146, Sub-Article 2B. A replacement of a deputy president under Article 149 is not an election. And I must confess that Article 149 was perhaps not worded very elegantly, because what Article 149 does is that Article 149 almost seems to have ended prematurely, because it says within 14 days after a vacancy in the office of the deputy president arises, the president shall nominate a person to fill the vacancy. So it's a nomination. The word used there first is nominate. A person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. It doesn't say anything after that. But one of the things I found when I examined another statute with similar provisions, this is Section 32D of the County Governments Act. Section 32D of the County Governments Act is actually a lot broader. It explains how that vote will be conducted, the time periods for it, the threshold for that vote. It's a lot more elaborate. But one of the things it makes clear is that the vote akin to Article 149 is an approval. It's not an election. It's an approval. And if one were to examine the Constitution further, everywhere the word election is used, and just by way of a few examples under the Constitution, Article 86, Article 87, Article 83, all of those articles, including the powers and functions of the IEBC, which my learned friend Mr. Ndegwa will be speaking to later, all of those make it clear that the election contemplated is a contested election with voters under Article 1. 14 million Kenyans. That is what the Constitution understands as an election. That then invites the jurisdiction of the Supreme Court of Kenya under Article 140. So it cannot be that the respondents get to make 2 opposing arguments. They argue that because this is their argument, this is an election, so you can only go to the Supreme Court of Kenya. But they then argue this is not an election that requires the IEBC. That's one of the things they've argued. Because an election requires the IEBC, as properly understood. So even that argument that the Supreme Court of Kenya is the only one that has the repository of jurisdiction to determine this matter does not find any basis, does not find any grounding in the Constitution of Kenya. You can also look at Article 106(2)(a) for what they discuss when they talk about an election. So Article 149(1) does not envisage any contest. The president nominates one name. And while I'm here, let me deal with an elephant that my learned colleagues will be throwing at you. It's actually more of a monster. In response to what we are telling you, they will tell you there's a public crisis of monumental proportions not seen since the late Daniel Arap Moi told us that he will appoint a vice president if it increases the sufurias of ugali in our houses. We'll be told this is the worst thing that has ever happened. There's a vacancy. Answer number one, Article 148 does not 148, sorry, I believe I'm talking about the sequencing where the Speaker of the National Assembly is the third in command, so to speak, when there's a vacancy. I have been waiting for my good friend Mr. Mlimani, who represents the Speaker, to shoot up to his feet and protest loudly that his client is not a vacuum. Because the Constitution says, when, I think it is, this is Article 146, Sub-Article 2B. If the office of Deputy President is vacant, or the Deputy President is unable to assume the office of President, the Speaker of the National Assembly shall act as President, and an election to the office of the President shall be held within 60 days after the vacancy arose in the office of the President. Two things to note there. In that article, the framers of the Constitution contemplated a vacuum in both the presidency and the deputy presidency. And it is at this point where my good friend Mr. Mlimani says his client, Anatosha.
Maybe you'll say it.
I'm almost certain in the event that my good friend Mr. Kamodo described here a few days ago, when he said the president might go to won't come back from, that we will all say we're Anatosha. He did. The record says so. Yeah, but we understood him. He was not wishing ill. So that's the first thing. The second thing, my lord, is that they contemplated we can operate for 60 days, 2 months, without either a president or a deputy president. The world will not collapse. Kenyans made adequate arrangements for the caretaker, while those two are not with us. And there seems to be something magical about these 60 days that Kenyans clearly had. Because under Article 149(1), when the deputy president is impeached or there is incapacity, the president has 14 days to nominate a candidate to the National Assembly. That is number one. And because it is not obvious, or it is not a matter of course, that the National Assembly will approve that candidate, it must be contemplated that the National Assembly can refuse to vote for that candidate. So those 14 days can be repeated, which is what the Constitution says. If Parliament rejects the first candidate, the process is repeated again. And the Constitution seems to contemplate can be repeated almost indefinitely until the President comes up with a name that is acceptable. So that is number one. And there's no crisis. The world will not end as Parliament rejects those candidates. So that's number one. But the President having nominated a candidate, the National Assembly itself has then another 60 days. So we can again operate as a country for 60 days without a deputy president. And so I return to what the Supreme Court said in the Sonko case we must do, and has not been done, has not been afforded to our client, the Deputy President. This is what the court says. This is the Supreme Court again at Article 114. And it's interesting because what had happened in the Sonko case, the court actually found that Sonko was not properly before it. But they then said they converted the proceedings into an advisory opinion. So they're actually giving this as a template for courts, such as this honorable court, to follow. Paragraph 114. To the question whether due process was followed in the removal of the appellant, the Audi Alteram Partem rule requires that those who are likely to be directly affected by the outcome of a decision should be given prior notification of the action. So they give a whole list of what must be done. Prior notification of the action proposed to be taken, of the time and place of any hearing that is to be conducted, and of the charge or case they will be called upon to meet. They must be given an opportunity to be heard. Now, it is not a matter in dispute that on the night the Senate, I and my colleagues on both sides were present in the Senate, our client was taken ill. I have subsequently read in the newspapers he had a broken heart for good reason. So he is taken ill, and the Senate then takes a vote. And this was important because the Senate had 2 days left, even in their own self-prescribed time limits. They voted, and this was not an electronic vote. They voted on acclamation to reject a motion to extend time for the deputy president to appear
My
in
Lord,
court.
if I may, I am compelled to interrupt. My Lord, learned counsel is misleading the court. When on affidavit, it is clear that the Senate votes electronically. Senate does not vote by acclamation. I do not know what paragraph is addressing himself. Perhaps he can point the court to the paragraph he's addressing himself to on the question of acclamation. We can't just sit back and watch Mr. Macharia mislead the court.
I was personally there. Senior Counsel Mwita was there. The entire team, most of them were there. On the question of extension of time, it was by acclamation. All the ayes and all the noes. That's what it was.
And the senator was not.
Yes. And I would ask him to please wait. He'll be a bit more bothered when I finish with my submission, so he can be bothered fully when I finish. So this is what the court says. They must be given an opportunity to be heard, to call witnesses, to be represented by counsel, to be availed adequate time and facilities to prepare, and if the accusations are proved, to be given the reasons. This is important. The Supreme Court says you must be given reasons for your decision. There are no reasons. They voted on grounds submitted to them by the National Assembly. They did not give reasons for that decision. Of course, beyond there, they are also entitled to challenge the decision. Again, you've been told these decisions are not challengeable. The Supreme Court says the accused must have a right to challenge the decision, if against them, before a higher court or tribunal. At paragraph 115, Article 47 of the Constitution enshrines the right of every person to fair administrative action. The manner of actualization of those rights have been enacted in the Fair Administrative Actions Act. Now, when this Honorable Court retires to do its ruling, I would invite you, with tremendous respect, to pay attention to sections 4 and 5 of the Fair Administrative Action Act. They're important in more regards than one. Senior Counsel Paul Mwite has alluded to the question of public participation, and so will some of my colleagues who will come after me. When the National Assembly conducted what it called public participation, it did not avail to the public the response by the Deputy President. What they did is prepare a charge sheet, a copy of which you will find as Annexure 8 of our affidavit in support of the petition, which for ease of reference is at page 498. That charge sheet asks 3 questions. It first sets out the 10 grounds that the motion promoter had set out, and then asks people, do you agree that the Deputy President should be impeached on these grounds? Do you not agree? And then there was a third one, other. That was it. They were not told what his response was, nor was he given an opportunity prior to this process. Because the only way, and you'll find that this is one of the things the Supreme Court says under the Article 47 and Fair Administrative Action Act, the participants in this public participation must know both sides of the story to make an informed decision as the people who voted in this man. The court then goes on at paragraph 116. In the process of removal of a county governor, and for this case, the deputy president, the right to fair administrative action under Article 47 and the right to fair hearing under Article 50 of the Constitution all accrue, and I'm paraphrasing here, to the deputy president before a decision to remove him or her from office is reached. An unfair removal is one which goes against the principles of natural justice, just like I've demonstrated, which implies that no adequate notice was given, that there was bias, and where the hearing was not fair. In our amended petition, which you will see in the fullness of time, we have given particulars of how each and every of these issues was violated. The Senate and the National Assembly, first and foremost, constricted the time allowed by the Constitution for themselves. They cut their own time short. And so no one had sufficient time to do anything. We have said they introduced new evidence as the trial was going. There was panel beating as the matter was going on. And as I've said, there was a lack of fair hearing. Though, this is Supreme Court, though a political process, impeachment is sanctioned by the Constitution and the law and is not a platform to settle political scores. This speaks to what Senior Counsel Paul Muite said a few minutes ago. It's not an issue of ticking boxes, going into a room and saying 300 of us have said you're a bad man, you must go. You're a bad woman, you must go. You must comply with each and every of the provisions of the Constitution. Bearing in mind that the removal architecture in the Constitution, the law, and the standing orders are designed to achieve accountability, political governance, and personal responsibility, and are not aimed necessarily to find criminal responsibility. On the question of natural justice, this is what, this was a decision by, I believe, your brother, Justice Odunga. It's in our list. This is miscellaneous civil application number 266 of 2017. He cites at paragraph 69 a case, I believe, from Uganda. It is a cardinal rule of natural justice that no one should be condemned unheard. Natural justice is not a creature of humankind. They're asking you to take away a creature, and let me read to you what it says. It was ordained by the divine hand of the Lord God. What God has given us, do not allow these respondents to take away from the deputy president. And that any law that contravenes or offends against any of the rules of natural justice is null and void and of no effect. The rule, as captured in the Latin phrase audi alteram partem, literally translates into hear the parties in turn, and has been appropriately paraphrased as do not condemn anyone unheard. That is what the Senate did to the deputy president. You cannot allow their resolution to stand. There is a decision, I will not read this for you, but this is a decision of the High Court, a 3-judge bench, Republic versus National Land Commission. I believe this is miscellaneous application number 266 of 2017. At paragraph 109, the decision of the Supreme Court of Kenya in Speaker of the National Assembly versus Attorney General and 3 others, where the court again restated, the Supreme Court, your jurisdiction in these circumstances. And then to the Senate proceedings I've just read out for you. In the Wambora, in the Martin Wambora case, this is what, this is the case, this is, it's cited in the Mike Sonko Mbuvi case versus Clerk of the Nairobi County Assembly. At paragraph 226, I believe this is the High Court decision, this is what the court said about what my good friend Professor Ojenda was getting a bit hot under the collar over. Although it does not fall within our remit to direct the legislature on how to perform its functions, we are of the considered view that impeachment of a governor is a serious undertaking, just like a deputy president, as the end result can lead to the removal of a popularly elected governor. the deputy president before you and the president who ran for election in 2022 were elected by a vote of slightly over 7 million people in this country, out of 14 million people who participated. It's a very serious matter. For this reason, we recommend that it will be desirable that future impeachments proceed through the committee route as opposed to the plenary. This is what the court is saying. We say so because when the special committee is appointed, it has 10 days to deliberate on the matter, thus giving ample opportunity to the parties to adequately prepare their cases. The Senate chose not to avail itself of this constitutional mechanism. The committee gives the perception that each member is actually engaged in the process as opposed to the plenary. The trial of the deputy president was held entirely in plenary. And a lot of things, when you look at the Hansard, for example, there was a lot of issues raised about a will, about a succession matter that has nothing to do with the Constitution of Kenya. When you look at the Hansard, a lot of things that had nothing to do with this constitution, and here's the problem. The committee gives the perception that each member is actually engaged in the process as opposed to the plenary, which can be perceived to be a mob lynching process, which is exactly what happened. That is our submission before you. It is what my late member of parliament from Kangema, the late John Joseph Kamotho, used to call kura ya makelele. Now, under the grounds for granting a conservatory order, one of the issues the court is called to look into is the question of whether the orders or whether the hearing will be rendered academic or nugatory. Now, at paragraph 20 of our supplementary submissions, which are dated 28th of October, 2024, we have cited before you a case by the Court of Appeal, Attorney General versus Matindi, and 55 others, where the court explains the following. A successful appeal is not reduced to a mere Pyrrhic victory or paper judgment. Whether or not a matter will be rendered nugatory is determined on a case-by-case basis, depending on the peculiar circumstances of the case. But ordinarily, the court will grant relief if what is apprehended cannot be undone once it happens, or cannot be undone without undue hardship or expense, or cannot be adequately compensated by an award of damages. The court takes into account the respective hardship that grant or refusal of relief is likely to wrought on the parties. I want you to take my colleagues' submissions where they say you cannot undo. Once a new candidate for deputy president is nominated and sworn in, they say the court has no jurisdiction to undo that appointment. This is what they're telling you. You cannot undo a deputy presidential nominee who has been sworn in and has taken office. This is what they're telling you. At any length, they tell you, this is a political question, don't even look at it. That's why they began. Don't even look at this. The president knew what he was doing, take him at his word and at his actions. So that's one side of the balance of the scale. On the other, you have a sitting deputy president who is before a court of law as he ought to be. If, in the unlikely event, his petition were to fail, all he does is go back home and we swear in the new one once the petition is dismissed. But conversely, if you swear in a new deputy president, you kick in motion a whole series of events, including a president, a deputy president, who is now exercising constitutional mandate, who is chairing cabinet committees, that may ultimately be found to have acted outside the Constitution of Kenya. The balance lies in granting conservatory orders so that we can do this in a civil manner. What former Supreme Court judge of the Supreme Court of Kenya, Justice Ojwang, used to call a pacific resolution of the dispute. As I said, the Constitution has given ample time for all of us to interrogate these questions. 60 days is the magic figure the Constitution gave us. Let's not be in a rush to undo the timelines given to us by the Constitution. And finally, the decision of, I believe, Gachagua Munya, the question of the public funds that are expended, swearing in a new deputy president, getting him a whole fleet of cars and workers, and the trappings of power, and as is the custom, perhaps even doing the road to his village home, all these sort of things. So let's hold our hands until we can determine whether the process that led us to this day was done constitutionally. That is the Peter Gatirau Munya decision. My lords and your ladyship, the decision you make in this matter will echo in eternity. It will be a turning point as to whether we continue being a constitutional democracy or a dictatorship and an autocracy. I beseech you, do not let us go down the path of autocracy and dictatorship. Thank you for the privilege of your attention and your time. Unless you have any questions for me, I'll hand over to one of my colleagues. Thank you.
Thank you.
My Lord, my name is My Lord, my name is Kibe Mungai. The team leader is Paul Muite, Senior Counsel, assigned this application, the one from Kerogoya, to me, Professor Ogada, and Mr. Ndegwa Jiro. As I had already indicated to the court, and with the benefit of the submissions from my learned colleagues, we shall try to do our business within an hour. So I'll start first, followed by Mr. Ogada, and then Mr. Ndegwa, for purposes of presenting that application. My Lord, let me start by thanking the court for the decisions that it rendered on last Friday on the questions of directions that it gave for the hearing of the petitions that are before the court. My Lord, I confirm that the process of amending the various petitions is ongoing and will be filed in accordance with the timelines fixed by the court. My Lord, going by the timelines that you gave, it is also my pleasure and appreciation, and that is in ensuring with the compliance with the Mutunga rules, that it is possible for your lordships to ensure that in the same way that the month of October we dealt with the political aspects, with the political phases of impeachment, that it is now possible, courtesy of your directions, to ensure that we can be able to have a judgment on merits for purposes of the various petitions that are before you. That would be an absolutely important issue for this court to remember, because it is being made as if it will not giving due process and ensuring substantive hearing of this matter, that we shall be here until forever. My Lord, all these businesses can actually be concluded within the month of November. That being the case, my Lord, by way of introduction, let me say two things in my own words as counsel representing, I believe, the 4th to 8th petitioners who filed the application that is before the court.
The date of your application?
Yes, my Lord, that is exactly the issue. 18th, my Lord. The application was filed on the 18th of October. Yes. If we put it there. Okay. My Lord, 18, it is supported by an affidavit sworn by Honorable David Munyi Mavenge on the same date. My Lord, for purposes of the documents, let me start there. We have filed submissions. The submissions were filed yesterday. There is a supplementary we filed today, and we have filed various responses to the affidavits to set aside that my learned colleague, Mr. Ogada, will be referring to them. My Lord, that being the case, I wanted to say that by way of an introduction, there are two broad issues that I can be able to say. My Lord, thank you. Yes. My Lord, the first issue is that the petitioners moved the court in, petitioners applicants, moved the court in Kerugoya in view of the fact that under Article 3.2 of the Constitutions, every citizen of Kenya has an obligation to defend and protect the constitutions of Kenya. That's a broad mandate. And of course, further to the other mandate, that under the Bill of Rights, from Articles 19 to 23, where the Bill of Rights is being violated, they are permitted to come to this honorable court to seek for the appropriate reliefs. And therefore, that is the basis upon which they came and have moved this honorable court. My Lord, the second broad issue that I wish to cover at this particular stage is to point out that what is basically the big thing about the matters that are before you. My Lord, the big issue for purposes of the matters that are before you is that these impeachment proceedings, after you hear us, two possible scenarios are clear. Number one, the Deputy President, who has already argued his application, as his advocates has pointed out, is an elected Deputy President, an election that was conducted on the 9th of August, 2022. My Lord, on account of the vote of impeachment passed by the Senate on the 17th of August, 2024, if the process concludes in accordance to the manner in which it has so far been implemented under Article 149(1) of the Constitutions, it would result into Kenya having an appointed president 2 years after one who is elected was put into office. My Lord, that's a big thing, whichever way you look at it, for the simple reason that one of the important devices of the 2010 Constitution was to ensure that the holders of the offices of President and Deputy President have the direct mandate of the people. So, in a matter where that important issue of our constitutions could change, it is our submissions that every absolute care must be taken to ensure that the process and the law leading to this very critical political and legal transformation on our constitution has been addressed. How would this be addressed? My Lord, we shall be arguing together with my learned colleagues that the only way in which this can be done is through the hearing on merits of the petition that are before this court. My Lord, having given those introductory remarks, let me come to the application of the 18th of that day, and by highlighting the issue that we both clearly know. My Lord, impeachment, and many cases, I will not go through them. The many cases that have been cited of impeachment shows that impeachment in Kenya has 4 processes. One, allegations are made, that is purely political. Muduse went around, collected his evidence, presented. There was a motion, I believe, dated 29th of September, asking Parliament to have this 26th. I'm told 26th of September. That's the stage 1 of the political process. Stage 2 of the political process is the stage where the National Assembly approves by a vote of 2/3 of all the members to allow to reject the impeachment motion. My Lord, that was done. There are various issues that have been raised in the majority of the petitions that will be argued in the fullness of time that shows the significant problems when this matter was at the parliamentary level. Topmost of them being the impartiality of the Speaker and the Deputy, together with the manner in which public participation was handled. Stage 3, my lords, is the stage of the Senate. The law clearly talks about what the Senate should do, how the voting should be done, and again, there is evidence. My learned colleague, Mr. Ongoya, and Honorable Muite, they pointed out the significant problems that we had there. I am most interested, my lord, in the fourth phase. The fourth phase of impeachment, as it has now been established in our jurisprudence, is where these courts seeks to establish whether there was compliance with substantive law and procedural law by the political organs upon which the mandate of impeachment has been entrusted upon by the Constitution, other laws, and the respective standing orders. Again, my lords, that phase that where the court is supposed to deal with this issue, it is our submissions that this is the stage that this honorable court must ensure, because it is the court that all aspects and proceedings are dealt with in a manner that we all had, and I'm happy for the time that the court has agreed to allocate us, so that the court with sober minds can be able to decide, have the laws of our countries been upheld or not. My lord, there are clear guidelines that have been set out by our constitutions for purposes of doing that. And my lord, because we are here because of an applications for conservatory orders, under Article 159 of the constitutions, this court has an express duty that in exercising the delegated judicial power of the people of Kenya, it is required, the certain guidelines have been given by the Constitution under Article 159, that is besides other provisions of the Constitutions. And one of the most important one is that that the court will do substantive justice. Substantive justice is an important issue, and it has specific meaning through the very many decisions that have been rendered over time by the courts of this country. And the clear meaning in plain English, because it is important we understood in plain English. In plain English, it means a very simple things. That, for example, my lords, if we have a case of a goat, Mr. X and Mr. Y have a case of a goat, this goat should remain alive and should so that at the end of the decision, the court can decide whether it belongs to Mr. X or Mr. Y. That is a very simple meaning of substantive justice. So that, my lord, substantive justice, therefore, conservatory orders, is a mechanism that our laws preserves the goat. Our laws preserves the subject matter of the case. The subject matter of the case, my lord, is the questions of vacancy in the office of the president. Going by the Senate, the deputy president was impeached. On account of the orders that have been given, that office is yet to be filled. So that, my lord, the question, therefore, is easy to define and can be defined this way. That, as we wait for the hearing and determinations of this case, it cannot be settled at the interim level that the Honorable Kindiki will now be the Deputy President of Kenya, so that as we argue the petitions, there is already the impeachment process has been concluded to the disadvantage of the other people, of the other person who is seeking the same office. So that, my lord, is a simple issue that is very easy to define. So that, my lord, we shall be arguing that when we come to that particular issue, why on earth, because you have before you, because if a conservatory order is the legal mechanism, the legal device that is established by the constitutions to preserve the substratum of the matter and for this court to do substantive justice, how on earth does the respondents expect that substantive justice will be possible if the trophy that is being tussled over, that is being contested over, is handed over to them? My lord, all systems of justice would be offended to be told that it is possible at halftime for one team to be declared to be the winner before the matches is concluded. Why can't we wait for all these issues to be concluded? It is a simple meaning of what substantive justice is all about. And the courts, the duties of the court to ensure that the ring is held even for all the parties so that we do not argue over an academic matter, which would be the worst issues that can happen. My Lord, there is the case of the Gatirao Peter Munya. I'm coming to the applications for conservatory order. The principles are very clear. I just need to go on them as quickly as I'm able to. Under Gatirao Munya and other decisions, we have a big authorities, many authorities. The issues were set out very, very clearly. And there are three tests. The first test is on the prima facie case. My Lord, my learned colleagues have set out the various many legal issues that are there. That from the standpoint of the applications that we are arguing before you, there are 5 issues for purposes of the prima facie case to comply with the Gatirao Munya case. The first one, my Lord, is public participation. I don't need to go into that. It's a substantive issue in the majority of that issue. My Lord, the second issue is what we call the legality of the standing orders of the Senate. My Lord, in the petition filed in Kerugoya as 015, the petitioners, amongst other things, are saying that although the Constitution provided for clear timelines on how, for example, the business is going to be conducted, and specifically said that this investigative committee is the only committee that can be able to discharge that constitutional function, the Senate established standing orders under which the plenary of the Senate can also resolve that issue. The Constitution of Kenya does not provide for a mechanism on how the Senate can discharge that function. But it is very clear on how that investigating committee is supposed to conduct its business and how the right to hearing is to be given after a finding has been made that there is a case worth responding to. My Lord, I submit that's a big issue on the standing orders that were used to pass the vote of impeachment. The second issue that has been sought in that case is the issue of interpretation and application of those laws on impeachment, 44, all those laws, 48, 144, 144, 149, all those have been raised. My Lord, as you clearly know, this is a first impeachment for purposes of those laws. And therefore, if a question of interpretation has been raised specifically before you, it underscores the necessity to ensure that on merits, this court actually determines and interprets the law so that the next time we have probably to do it against the president or against Kindiki if he gets there, the law would be clear and we shall not be going through all these things. So a serious issue has been raised by that petition. The other serious issues that have been raised is, of course, the fairness of the Senate proceedings. I will not go into that because already the lawyers for the deputy presidents have raised that issue. And the fifth important issue is the issues of nominations of the Honorable Kindiki. There are issues of the nominations. My learned colleagues will say more about that. But as we wait for their turn to come, the only 2 issues that I need to say at this early stage is to point out the fact that under the constitutions, I believe Article 137 of the Constitution, any person occupying the office of the deputy president or the office of the president must be qualified in accordance with the constitutions of Kenya. Under the impeachment articles of the constitutions, these issues of the constitutions on the qualifications are not set out. So that because they are not set out, it is an assumption that when reading the Constitution holistically, this court will go to those other specific provisions of the Constitutions where the issues of qualifications are set out. My lords, those issues of qualifications are many. One, and the body under the Constitution, my learned colleague Mr. Ndego will say more about it, is that the IEBC confirms whether any person has those qualifications or not. I don't think that is a contested issue. I believe it is also not a contested issue that at the time that the President of Kenya appears to have received some letter from IEBC confirming that the Honorable Kindiki is duly qualified to hold the positions of Deputy President, courtesy of Article 149 of the Constitution, we did not have IEBC. Of course, various arguments can be taken by the parties that are before you. Those arguments cannot be concluded. Those arguments can only be arguments to justify whether or not the conservative orders will remain in place or not. But they'll have to be settled when the petition has been heard. The second important issue on the aspect of the nomination of Kindiki that I need to point out is this, that even assuming the president did the right thing and everything else that he was doing, this court should be concerned by the fact that whilst the case was still going on before the Senate, the National Assembly scheduled a meeting by the National Assembly, which under Article 149 has 60 days, a meeting to occur the following day, within about 7 hours after the vote of the Senate. Why should this concern the court? It should concern the court for the simple reason that under Articles 10 and 118 of the Constitutions, Parliament cannot pass a law or make important decisions like approval of the Honorable Kindiki without engaging in public participation. The cases are so many for me to cite them. The jurisprudence is so clear for it to be disputed. So that, my lord, the argument that we shall be putting on the issue of the nominations, on the face of it, unless this honorable court is able to say that at this stage, that public participation does not apply to the nomination and approval by Parliament, then, my lord, it is clear that this is the kind of case in which you are duty-bound to confirm the conservatory orders until this petition is heard and determined. Because the precondition would have to say, we have excluded this process from public participation. You would have to resolve the main issue, one of the main issues, at this stage before the petition has been heard. That would obviously be irregular. Now, none of us expect it to happen. I still wonder how the respondents would expect for them to get such kind of an order. I go to the second test, and this is the test of whether those orders will be rendered negatory. My lords, again, I will not use the word no-brainer, but my lord, this is not a difficult argument to be able to resolve, and I believe I had a little bit say something about it. But my lord, the whole argument would be this, that if the whole argument, and that has been our case since we first came here last Tuesday, that we cannot, my lord, be able to have a situation in which the petitioners are saying the constitutions of Kenya has been systematically violated, and that all these obsessions with the application to set aside the conservatory orders that are in place are meant to complete the violations of the constitutions. My lord, under the constitutions, your first duty is to defend the constitution. That duty is particularly greater for the simple reason, is it called Meduse? The MP, Metuse, that one. When the mover of the motion had that duty under the constitutions, President of Kenya had that duty. conducting, making appointment under 149. National Assembly had that duty, and the Senate. But my lord, you are saying in those 5 instances, the Constitution has been violated. And because, my lord, the Constitution has been violated by individual state officers who are under a duty to uphold the Constitution, then the duty of this court to ensure that we do not turn this Constitution into a mere platitudes, into a hollow documents, a false prospectus, is all the more greater. And it is for those reasons, my lord, that I would be saying that everything would become nugatory when they can be able to say, mission accomplished. They can go one day after the ruling. They can go to Uhuru Park or whichever other place for them to say, we are swearing Kindiki. That would be a mockery of justice. But there is a greater mockery of justice that I would want to point out. Because this thing, and to break it down for the people, every order, in the normal litigations we do with every day, and you say somebody's rights are going to be violated. If somebody is saying I should not be hanged, I was not convicted properly by the High Court, if, my lord, that person is hanged before he has been heard by the Court of Appeal, clearly it would mean that the process of justice had not been completed, yet we have hanged the guy. My lord, in America, they keep on hanging people. Many of them terrible criminals, mass killers. But, my lord, you will observe that at the time when we see these televised killings in America, it is always after they have exhausted judicial process, so that they are sure that process that are irreversible take place after every legal benefit and protection has been accorded. One of those that is important, my lord, is captured under Article 27 of the Constitutions, the right to protection of law. So that the issue, as long as I'm in court, the matter is not yet over. It might well be possible that we might lose this application, the interim application that is before the court. But we might also win it, and we are likely to win it. So that because, my lord, of that issue, that a person may actually succeed at the other stage is the reason why you prevent taking irreversible decisions. And, my lord, what is the scenario that we are talking here? My lord, with the scenario here we are talking about here is simple. Immediately after assuming the orders were lifted, that's the scenario I want to describe. What is it that is going to happen? My lord, we would have a scenario where the Chief Justice, whilst these proceedings are pending before the court, would have to preside over the swearing in of Honorable Kindiki.
My lord, is it in order for Malali friend to keep speculating about the swearing in of Professor Kindiki?
The issue of swearing in is
also, and he's referred to it 3 times now. This is the 4th time.
My lord, I believe that's the law. They have been saying they want to.
And my lord, whereas you are
then.
I was to ask my lord, what is the dispute before you? Is it the impeachment and whether it was lawful, or is it the nomination of the second interested party? Because
first of all, it's both, and I would want some protection for me to conclude so that we are all fair. They will have their time to respond, and I will not interfere with it. My lord, so that the important scenario that we must seek to avoid is a situation, and this is matter, it is also a matter both of the Constitution and statute law. My lord, the issue is that if we get ourselves into a situation in which the Honorable, the Chief Justice, might have to preside over the swearing in of Honorable Kindiki while this petition is pending, my lord, that, to borrow the words of Honorable, my friend Muigai, Senior Counsel, would be the greatest absurdity that we can encounter. Why is it an absurdity? It's an absurdity, my lord, for the simple reason that one of the authorities that we have cited is the Assumption of Office Act, where, because of the experiences that this republic went through in the years 2007, 2008, specific laws had to be made to ensure that not only will this event be a public event, that's number one, but the more important issue from the standpoint of law is this, that before we get there, all legal disputes, contestations over the right to occupy that office would have been resolved. And my lord, that is the reason precisely why they say, after the Supreme Court has confirmed the validity of those two positions, then you do the swearing. My lord, it would amount to taking us back if that aspect, that rule of civilizations, were to be taken away on account of the setting aside of the conservatory orders that were issued, and for very good reasons, by your brother judges. I don't know whether there was a sister, by your brother judges. So that, my lord, the issue, as far as we are concerned, that is an absolutely important issue. We go to the next important issue, public interest. My lord, public interest has been defined in very many cases that are before you. And my lord, these public interest issues are just supposed to ensure that in administering justice, the court will do the right thing. Because we actually have a transformative, one of the best constitutions in the world, for the simple reason that we wanted to be a good example across the world as a leading constitutional democracy. And as a leading constitutional democracy, the issues of public interest is placed at the heart of our constitutional order. I go, my lord, to the definition. This is the only long passage that I will be reading. And these I gave the supplementary authorities earlier. This is in the famous case of Murungaro, Christopher Darathi Murungaro versus Kenya Anti-Corruption. This I'm citing the passage appearing at page 7 to 8. My learned senior, Gethu Muigai, will be familiar with this decision. My lord, from the last paragraph, what did the Court of Appeal say on public interest? I read, it said as follows. The matter, Professor Muigai told us that their strongest point on the motion before us is the public interest. We understood him to be saying that the Kenyan public is very impatient with the fact that cases involving corruption or economic crimes hardly go on in the courts because of applications like the one we are dealing with. Our short answer to Professor Muigai is this. We recognize and are all aware of the fact that the public has a legitimate interest in seeing that a crime of whatever nature is detected, prosecuted, and adequately punished. But in our view, the Constitution of the Republic is a reflection of the supreme public interest, and its provision must be upheld by the courts, sometimes even to the annoyance of the public. The only institution charged with the duty to interpret the Constitution of the Republic and to enforce those provisions is the High Court. And it is permissible with an appeal to the Court of Appeal. We have said before and we repeat it. The Kenyan nation has chosen the path of democracy. Our constitution itself talks of what is justifiable in a democratic society. Democracy is often an inefficient and at times a messy system. A dictatorship, on the other hand, might be quite efficient and less messy. In a dictatorship, we could simply round up all those past persons we suspect involved in corruptions and economic crimes, simply lock them up without much ado. That is not the path Kenya has taken. For the rule of law, and the rule of law implies due process. The courts must stick to that path, even if the public may, in any particular case, want a contrary thing, and even if those who are mighty and powerful might ignore the court's decisions. Occasionally, those who have been mighty and powerful are the ones who have run to seek the protection The courts must continue to give justice to all and sundry, irrespective of their status or former status. What orders should we make in the motion before us? So then, my Lord, I make 3 points with regard to what is public interest as understood by the Court of Appeal. Number 1 is that public interest means enforcement of the constitutions of Kenya. Secondly, my Lord, to make the point from what we have said, that the first duty of ensuring that you both protect the Constitution of Kenya and you protect public interest is vested in the High Court. Every other court above the High Court, the Court of Appeal, the Supreme Court, they can only do that on the basis that sitting in an appeal on a decision already made by the High Court. So that, my Lord, it will be the submission that this reinforces the huge burden that this court must undertake. And, my Lord, the final issue that was being understood here is to say a constitutional democracy would not mean anything unless due process is upheld. And due process is the first duty of the High Court to ensure that in whatever dispute that is before the court, before it is decided, the court has confirmed due process has been observed, and as a constitutional democracy, that is a standard, because they try to compare our dictatorship, that as a constitutional democracy, we can live with a decision. As my learned colleague, Mr. Ngoya, was saying, we cannot possibly live a decision in which we would be seeing the Chief Justice, where, if that were to be the case, you would be seeing the Chief Justice swearing on Honorable Kindiki while we are arguing this matter before the court. So the rules are clear. The rules do not require much elaboration on what they mean. And since that criterion of public interest has been made by the Supreme Court itself, my Lord, I urge you to uphold it in the manner that will best ensure that the constitutions of Kenya and its dignity have been upheld. My Lord, there is the question, so that I believe that we are very clear on public interest, except to emphasize that for the specifics of this case, what does the call of public interest require this court to do? It's a simple call, 5 quick things. Number 1, to confirm that the law on impeachment has been properly interpreted and applied. That's the first issue. To confirm that the laws on impeachment has been properly interpreted and applied. Number 2 is to achieve substantive justice for the parties, so that when a judgment will be issued by this court, at least everybody can win something, that nobody goes home with a hollow victory. That is the whole idea of substantive justice. The third issue is to determine that the issues of the violations of the constitutions is done while the matter is still alive before the court. My Lord, very serious issues on Articles 27, 38, and 50 of the constitutions have been raised. They are all under the Bill of Rights. We urge that while public interest needs to be upheld by ensuring that when this court pronounces itself in a judgment, those issues would not have been turned into academic. Number 4, my Lord, is to ensure that the integrity of the presidential or political succession that is written in express law under our constitution is not ridiculous or ineffective. And in those, I point out what we had said earlier. The desire of the makers of the Constitution was any person who will hold the office of Deputy President and therefore can potentially become President without an election ought himself to be an elected official. So that it's a big thing if this office, and without good reason, except political malice, is held by an appointed person. It is in public interest that an elected deputy president, except for the clearest of evidence, except for the greatest of sins that are clear to all men of justice, is not removed from office. Lord, the 5th issue is to do this, that this court protects the constitutions. I've already talked something about it, so I don't have to go much into it. There are only 2 decisions, before I sit down, that I would like to point myself to. There is the issue of Githunguri versus Attorney General. It is one of the cases that are before you. The facts in Githunguri are notorious, and they are also notorious for the simple reason that that decision, those old advocates who are there, Kina Paul Muite and Dr. Gibson Kamau Kuria tells us, it was largely, though it was a 3-judge bench, it was written in the style of Chief Justice Madan. My Lord, that issue said something that is important to me, the younger advocates in Kenya. And what it said is this: it emphasized the question of justice. And it emphasized the question of justice is the simplest meaning in plain English. You need to ensure everybody has a fair and square deal. This is to say that at the end of the day, everybody will leave the court and say, probably my advocate was as good as I thought, but the judge did their best. But at the end of the day, let it be very clear that the court did everything that is possible to ensure that justice in its substantive form is achieved. This decision was rendered in 1984, long before the article on 159 was written, and that is why it is celebrated. And my Lord, it is also celebrated, and I am mentioning here for that reason, whenever honorable men, candidates before the Judicial Service Commissions are called upon to name whose jurisprudence has affected them, it is Justice Madan that is mentioned very many times. I will strive to be like Justice Madan. And my Lord, it is for good reason. All of us celebrate Justice Madan because he strived to do justice. But my Lord, in the same case, the older lawyers also told us about Alan Hancock's, about Dugdale, and even about Chunga. They tell us all these stories. But my Lord, in those interviews, I do not hear anybody saying I want to be like Alan Hancock. So that, my Lord, I cite Madan in order to support the proposition that Judge Madan would never remove the conservatory orders that are before you, under the principles of doing justice and offering everybody a fair and square deal. The last case that I would want to cite, before I hand over to Mlimani colleagues, Professor Ogada, has he gone? Oh, I thought whether he has disappeared. My Lord, before I hand over to my learned colleague, is to point out to one little issue.
The petitioners, you have exhausted 2.5 hours. Budget how you are going to...
Yes, sir. Yes, my Lord, we are budgeting.
With the remaining,
yes,
no more than 30 minutes.
Yes,
anybody
Lord,
who wants to submit on your side,
yes,
we'll
try to do our best.
Have no more than 30 minutes.
Thank you. We'll do our best. My Lord, for purposes of this case, this is the only thing I'm citing before I go. This decision, like you've had very many other decisions on constituent power and everything, this will be an international decision. It's a decision that will be read by universities across the country. And therefore, the least that I can do is to confirm that the lawyers for the petition are still familiarized themselves, as Macharia tried to do, with what other courts internationally have said. There is just like a small issue that I want to address myself to. My Lord, in 1928, in the case of Olmsted versus United States, one of the most celebrated justices of the U.S. Supreme Court, Justice Brandeis, says as follows. This is important. Our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. End of quote. I quote the words of Justice Brandeis in order to make the point that in the matters, the proceedings before this court, we have been treated to a scenario under which an impeachment process that, if you read the constitutions clearly, is a process that ought to be a legislative one, a process conducted by the legislative organs of the Kenyan state, has been converted into an all organs of government project. With the result, my Lord, that if the petitioners turns out to be right, you would then find ourselves in a situation whereby, like in BBI, this process of impeachment of the deputy president may end up being indicted as being a process that ended up being a government project, contrary to what was clearly spelled out by our laws. And my Lord, if it turns out that all laws were broken, and virtually out of the constitutions, I was counting them yesterday, it looks at 30 provisions of our constitutions have been seriously violated in the manner that this process has been undertaken. Then we have a situations that Justice Brandeis had in mind when he talked about the government, which should be the lead in upholding the law, ends up being the principal breaker of the law, the principal violator of the constitutions. It is within your hands, your lordships and your lordships, to ensure that does not become our scenario. My Lord, Macharia, my colleague, emphasized something, but I want to finish by adding something. My Lord, in June 1982, when Kenya was legislated into saying that Kenya is a single-party state and KANU is the only legitimate organ, this was through a long process. Honorable Rengo, Honorable Mwite, Gibson Kamau Kuria have told me the intricacies of the day, what actually happened. My Lord, the month of October 2024 we have experienced events that the senior citizens of Kenya likened to the events of June 1982, when everything in Kenya suddenly changed. Kenya ended up to being it was a restricted democracy, but all the guardrails were removed after June 1982. Your Lordships, I urge you that if these petitions, if these proceedings end up in a manner that does not uphold our constitutions, then this constitution may face the same plight that the former constitution faced after the events of June 1982. We must hold and ensure the events of October 2024 remains regrettable and an aberration on Kenya's constitutional order, not the norm. My Lord, I am thankful for the time. My learned colleague, Mr. Ogada.
Thank you.
How many people are yet to speak?
For these applications, there are two. I was with Mr. Ogada and Mr. Ndegwa. They have heard you when you talked about 30 minutes. They will try to divide the time amongst themselves.
My Lord.
My Lord, I'm also...
Yes, my Lord, I was saying that we are also interested parties in the application and we would require 15 minutes.
We will reach you. Your time has not come.
Your Lordship, the presiding judge, Your Lordship, Justice Mrima, Your Ladyship, Justice Mugambi, I will be brief. A famous quotation says that while the legislature is the will of the majority, the court must always remain the conscience of society. That is the spirit of the Constitution 2010, and that spirit has been reiterated time and again by this court. Mine is two tasks before this court today. I will be going through a panoramic vista of the authorities before this court, and finally, I will go through the political question doctrine, something that has quite excited the other side, and to debunk the myth that the political question doctrine in any way applies in the context of the Constitution 2010. We are dealing here with an application for the preservation of conservatory orders, and insofar as the application in petition E15 is concerned in terms of prayer D and E, extension of those conservatory orders to cover the entirety of the proceedings pending judgment and determination. My senior colleagues have gone through the essence and the reasons why conservatory orders ought to be granted. Mine is just to buttress this, that I will add this court to look at the decision in David Ndii and others. That was a 5-judge bench decision led by Professor Justice Joel Ngugi as he was then. And in paragraph 29 of their ruling that is dated 26th February 2024, and in that decision, quoting a decision from the Supreme Court of Appeal in Nigeria, United Cement Company versus Dangote Industries, the court says that conservatory orders are prophylactic. They are intended to save the substratum of petitions. And as been ably demonstrated by my colleagues before me, we will sit at monumental oddity, the perfect storm in the teacup, when we allow certain processes to happen, including the swearing in of Professor Kithure Kindiki, who argued with me the BBI decision, that if his swearing in should go on, then these petitions will be rendered academic. That certainly should not be the legacy of this court. This court in the context ably articulated by my learned senior, Mlimani Ongoya. We have provided a couple of cases in our submissions to buttress what my learned senior, Mr. Kibe Mungai, has articulated in terms of the tests in Gatirao Munya. We have the case of Kanyada Kinyanjui, the Nolak case. These have been attached to a list of authorities. They express, in terms of fine legal distillation, what will mean by an arguable case, and in terms of that infamous term that was bandied here before, the term nugatory. It has been judicially defined. You look at what the Court of Appeal in Kanyada, Kinyanjui, and Nolek define nugatory to mean. In terms of public interest, we will invite this Honorable Court to look at the case of Ethics and Anti-Corruption Commission versus Professor Tomojenda and associates and others, whereby the Supreme Court says that an additional limb to be examined is public interest. And we have labored in our submissions, Your Lordship, the presiding judge, to itemize 7 items of why the Constitution, as was articulated by my learned senior Ongoya, why the Constitution qualifies as the highest embodiment of public interest. We are here to argue for a conservatory order to issue as a prophylactic device to save the Constitution. That's our constant north. It should not be forgotten. Still on the question of public interest, my good friends representing the first petitioner have in their bundle of authorities 2 cases. The Court of Appeal decision in Matindi versus the Attorney General, 2023 EKLR, the CAS case, famously called. And then we have the Ojo case, Ojo versus Agriculture and Food Authority and 8 others, 2024. I am reliably told that that was argued by my good friend, Professor Tomojenda, my senator, Queen's College alumni. And in that case, this is what the court said, in a nutshell, that we need to keep out a nominee from public office so as to protect the Constitution, the integrity of the Constitution. Keep out that nominee. Let them not go into office. That is what we have been arguing. Ojo, Matindi, CS. Oh, I argued CS, by the way. Elisha Ngoya went through certain positions in law as contained in Justice Mrima's decision, Justice Mwongo's decision, your own decision. Those decisions are not idle. They are not mere words in English. They bear legal consequences by the virtue of the doctrine of judicial comity, that when a court declares itself on a position of law, and in the context of these particular petitions, we are dealing with collegiate decisions. Those decisions enjoy protection by virtue of the doctrine of judicial comity. Lord Justice Newberger, in an authority that we have supplied, the case of Willis and Joyce, 2016. This is the 2 2018 appeal cases. We've provided that. Lord Newberger says this, that so far as the High Court is concerned, puisne judges are not technically bound by the decisions of their peers, but they should generally follow a decision of a court of coordinate jurisdiction unless there is a powerful reason for not doing so. That creates an honest presiding judge, Justice Mrima, Justice Mugambi, that the other side has to satisfy you that those courts, including yourself, made an error in making those determinations for you to depart from the same. Elisha Ngoya painted a beautiful picture of how odd that will be. We have also provided the case from the Supreme Court of the Parliamentary Service Commission versus Martin Nyaga Wambora. The court there examined decision-making and vacation of the same in the context of a collegiate court. The test has been given there by the Supreme Court. And what the Supreme Court says is that if this might be tempted to reverse what has been made in terms of decision by a collegiate court, then the error has to be substantial. It has to be demonstrated. It does not simply amount to a question of mere allegation, huffing and puffing. It has to be shown demonstrably to the satisfaction of this court. I want to move quickly to the question of political question doctrine. My good friend, my brother, Mr. Gumbo, has spent a lot of ink, black and white, submitting on this. And he submitted to this court the authority of Baker versus Carr. To him and those on that side who submit in that line of thinking, we say this, that the political question is an American constitutional emanation. It is a function of separation of powers unique to the American constitutional context. That's number one. In the context of the Republic of Kenya, that doctrine has been morphed and understood to mean justiciability and non-justiciability. And in our context, it has been understood to yield to notions such as ripeness, mootness. And this was done by no other than His Eminent Grace, the Lord Justice Mrema, in the case of Anthony Miano and others, was the Attorney General 2020 EKLR. Thirdly, the political question focuses on limitation by courts, on the court restraining itself from dealing with matters within the responsibility of the political arms of government. Now, in terms of the US context, and I have said that Mr. Gumbo has submitted on this case and we wish to respond to him. This is what they did not tell you in terms of Baker versus Carr. Baker versus Carr in 1962 lays down 6 factors that can be used in identifying what a political question is. So the political question within the American context is not a general rule of application. It is applicable, yes, but within certain parameters. And the context in which that political doctrine question principle can be used is where, number one, there is lack of a judicially discoverable and manageable standards for resolving the dispute. In other words, the judiciary does not have the wherewithal to deal with that question. Number two, the impossibility of deciding the dispute without being to the detriment of a political policy determination that has been made. Number three, the impossibility of the court undertaking such independent resolution without expressing a lack of respect to the branches of government, the political branches. Number four, the unusual need for unquestioning adherence to a political decision already made. Number five, the potential embarrassment from multifarious pronouncements by various departments on the same question. And sixth, a textually demonstrable commitment to the issue of a coordinate political department. Those are the 6 circumstances according to Baker versus Carr. So the question, Your Lordship, Presiding Judge, what will be the usefulness of this doctrine in Kenya? The Constitution of the Republic of Kenya David Ndii, and others, the Constitution of Kenya has an internal theory. As Elisha Ngoya articulated, and as was articulated in BBI, the Constitution is a transformative Constitution, such that our tenor, our tone in terms of Constitution is radically different from the American. From the text of our Constitution, this is what the Court of Appeal in the BBI decision said at paragraph 139 and at paragraph 144. At paragraph 139, the Court of Appeal said that the Superior Court, being this court, by virtue of Article 22(1), 23(1), and 258(1) of the Constitution, had jurisdiction to complete and incomplete breaches of the Constitution. Your Ladyship, the Lordships, the substratum in the BBI case was a bill that was stopped in its track before signature. That is important in terms of this context. At paragraph 144, this is what the Court of Appeal says, that when matters involve a threat to breach constitutional rights, justiciability requirements are satisfied and hence the court is allotted with jurisdiction. The court is seized with jurisdiction when a breach of the Constitution happens. From the constitutional text, plain reading, Article 4(1) read with Article 4(2), together with Article 1, provide an interface between law and politics. I repeat, 4(1), 4(2), as read with Article 1, provide an interface between law and politics. The requisite of power ultima, sovereignty in the people, and the requirement by the Constitution that government and governance must be in accordance with the Constitution, Article 2(1), our supremacy clause, ensures that politics are subordinated to the rule of law and constitutionalism. Article 3, the preservation clause. Everybody is enjoined to defend the Constitution. And that provision has normative significance in establishing a legal and moral commitment to uphold and protect, defend the Constitution. Article 232, an attempt to establish government, including appointments, otherwise than in conformity with the Constitution, is unlawful and unconstitutional. Article 2, sub-article 2, no person may claim or exercise state authority except as provided under the Constitution. In conclusion, your Lordships, your Ladyship, in an old story, and it's probably even true, when the authors of the American Constitution declared after months of work in Philadelphia that they had finally reached consensus, a lady by the name Mrs. Powell shouted a question to the revered Benjamin Franklin, an American statesman, who was then 81 years old. And this is what Mrs. Powell told Benjamin Franklin. Dr. Franklin, what have you given to us? A monarchy or a republic? And this is what, your Lordship, your Ladyship, Dr. Franklin answered the lady. A republic, if you can keep it. The judiciary must stand as the unyielding guardian of the Constitution, the protector of the republic, for when it falls, the pillars of justice and democracy begin to crumble. I submit. Thank you.
Thank you.
You, Bananjeru.
Yes, my lady, my lords.
How are you?
I'm well, my lords.
You have 10 minutes.
My lord, I'll try to do the best within the time allocated.
All right.
My lord, my lady, my lords, permit me to join issues with the earlier submissions made by my learned friends. And permit me, my ladies, my lords, to submit that my submissions will majorly deal
Can you join issues on the same side? Join issues? We haven't submitted.
What problem do you have with that, Professor Gender?
My Lord, join issues means he's on the opposing side, but he's supporting the applications as framed. So I don't know whether it is simply a question of not knowing that we haven't spoken, perhaps. He's running low on sugar.
My Lord, the presiding judge, you made an important point that we are Africans.
I think let Njiru proceed.
And he will have his time to speak the right English when his time comes. My ladies, my lords, my submissions will deal with the aspects of public interest in respect to the reason why the court must sustain the conservatory orders as granted by his Justice Mongo and Justice Mwita. Your Lordship, permit me to begin by drawing your attention to the dictates of Article 3, which requires every person to uphold and protect the Constitution from being violated. My lady, my lords, the Constitution that we are here to protect this afternoon is a document that is progressive in nature and that seeks to protect individuals who either serves in government or out government in whatsoever organ. My lords, in my address, I'll majorly deal with the question of the purported nomination of Professor Kithure Kindiki and whether the lifting of the conservatory orders will culminate into his swearing in and what that means in respect to the provisions of the Constitution. My ladies, my lord, it is clear that a purported process took place in Parliament that culminated into a name being forwarded to Parliament for voting. My ladies, my lords, it is important for us to interrogate the circumstances that led to the forwarding of this name, and whether or not that process is confirmed with the dictates of the Constitution. My ladies, my lords, on the 18th of October, we walked to what my learned friend Mr. Ongoya submitted on a memorandum by the President. The said memorandum, my ladies, my lords, indicates that the President sought approval and confirmation from the Independent Electoral and Boundary Commission. And the answer that he got was sufficient enough to afford him the courage to forward the name for voting in Parliament. But the question, my ladies, my lords, that begs an answer is, did the IBC possess the requisite constitutional capacity to submit or approve the said name for purposes of voting in Parliament? My ladies, my lords, the answer to that will be found in Article 88, as read together with Article 99 and Article 137 of the Constitution. Article 88, my ladies, my lords, creates the Electoral and Boundary Commission. And in the same article, my ladies, my lords, creates the functions of the Commission. You'll also find the same answer, my ladies, my lords, in the amended IBC Act. Most importantly, Section 10 and Section 11, which I'll be dealing with in the near future. My ladies, my lords, Article 99, together with Article 137, provides the qualifications for an individual to hold the office of the President, and by extension, the office of the Deputy President. It is important to note, my ladies, my lords, that in the event anything happens and the current President is incapable of executing the functions of the office of the President, the purported name, if sworn in, will be the person to take over. But will he have met the necessary requisite qualifications? And who is mandated to ensure that these qualifications are met? We submit, my ladies, my lords, that the only constitutional organ capable of executing that functions is the Independent Electoral and Boundary Commission. The court will take judicial notice, my ladies, my lord, that the commission as currently constituted falls lack of the commissioners. And the question therefore, my ladies, my lords, in the event the commission is called upon to evaluate the qualifications under Article 99 and Article 139, so that then, my ladies, my lords, a name can be submitted in Parliament for voting, who then is capable of doing that in the absence of the commissioners? My ladies, my lords, we submit that IBC as currently constituted can only execute administrative functions and it has no capacity or ability to execute the function under Article 99 as read together with Article 137 of the Constitution. My ladies, my lords, the Constitution as read together with the IBC Act has created distinct functions that for the commissioners and the secretariat. And you'll find that, my ladies, my lords, in the decision, consolidated petition number 305, which was between Engineer Mwaura Kamau, Charity Kaluki Ngilu versus EACC. A three-page judge, my ladies, my lords, had that to consider whether the secretariat, in the absence of the commissioners, can take the functions designated and exclusively allocated to the commissioners. My ladies, my lords, at paragraph 347, this is what the court had to say. From the foregoing provisions, it is clear to us beyond peradventure that the membership of the Constitutional Commission is between 3 and 9 members. In other words, the composition of the Constitutional Commission ought not be less than 3 and not more than 9. The court goes on to say that if the secretariat, and in this case, the CEO to the IBC, would then be seen to execute the functions of the commission, it would then mean that the commissions would go beyond the constitutional dictated number of either 3 or 9. The court said at paragraph 348, the said members, otherwise known as the commissioners, are empowered to appoint the commission's chief executive, known as the secretary. To contend that the secretary, who is an appointee of the commission, is part of the commission would mean that the commission would, where commissioners are 9, be composed of membership of 10. The court said one only needs to mention this to realize how ridiculous this argument is. It is therefore our submissions, my ladies, my lords, that the name that was submitted to Parliament is not capable of replacing, in the event this court dismisses our petition and upholds the impeachment, the Deputy President of the Republic of Kenya. The court further said at paragraph 353, I refer the court to have a look at paragraph 353 and paragraph 354. But of the most importance is what the court said relied in the case of petition number 46 of 201. The court relied in a Ugandan case, and this is what the court said. It is clear to us that under the Constitution and under the legislations, the foundation of the power of a secretariat is the existence of the commission. The secretary and the secretariat can only carry out the powers vested in their offices when the commission is in place, exercising its powers since they implement what the commission has approved or resolved. Again, I urge the court to look at paragraph 356 and also 358. But most importantly, your Lord, my ladies, my lord, is what the court is saying at paragraph 362. This is what the court had to say. We therefore also agree with the petitioners that any decisions purportedly transmitted to the DPP recommending the prosecution of the petitioners without the sanction of the commission would not be in compliance with the law and the constitution. We urge you, my ladies, my lords, to find that the name that was submitted in Parliament is not capable of replacing the Deputy President of the Republic of Kenya. Why is that important, my ladies, my lords? Because if the orders are lifted today, that will be the next course of action.
My lord, that's not a finding you can make in your ruling on an interlocutory application.
Well, why, my ladies, my lords? Because this is a train with many compartments and many stopovers. The next stopover that we shall land on, my ladies, my lords, if the orders are lifted, is to have a person who has not duly appointed in accordance with the Constitution taking over the office of the Deputy President. My ladies, my lords, permit me to draw your attention to paragraph 365, 336, and 337 of the same judgment. And this will be my final submissions in respect to this judgment. At paragraph 367, the court is saying, whereas a commission may be disabled in its ability to perform its functions, such disability does not automatically render the commission extinct. Such an event, in our view, only places the commission in a state of dormancy until such a time as it is able to carry out its functions. My ladies, my lords, I have perused the replying affidavit filed by Marjan on behalf of the IBC. He makes no reference to the memorandum filed by the President. My ladies, my lords, he technically makes sure that he does not make reference to that so that he may not be seen as if he has delved into the functions of another organ. My ladies, my lords, permit me to draw your attentions to section 6 of the appointment, I beg your pardon. Paragraph 6 of public appointment parliamentary approvals. And as you look at paragraph 6, also look at the definitions contained at paragraph 2 of the same act. What an appointment means and what a candidate means. And for avoidance of doubt, a candidate means a person who has been proposed or nominated for appointment to a public office. Section 6 creates the criteria upon which Parliament must follow so as to satisfy the need for public participation. It also creates the time within which this must be executed. It has been submitted that this was executed in a supersonic speed that took approximately 6 hours, and the Republic of Kenya had a new Deputy President proposed. But the question, my ladies, my lords, is, can this be done in the absence of the exercise of the sovereignty of the people of Kenya? If we were to allow this, my ladies, my lords, what will be the import and what will be left of Article 1 of the Constitution? Will it be to mean that Article 1 of power belonging to the people will be meaningless? Additionally, my ladies, my lords, what will be left of Article 10 of the Constitution that requires state organs to be bound by the provisions of Article 10 whenever any of them executes the functions bestowed by it by the law? My ladies, my lords, the question of public participation, even in the process of the nomination of the said candidate, is paramount. That under Article 118, Parliament is enjoined together with Article 10 to carry out public participation. And that is the only way, my ladies, my lords, that Parliament can be said to have exercised the sovereignty of the people of Kenya through the delegated democracy concept. That is to mean, my ladies, my lords, if we were to sanction whatever happened on the 18th and allow it to pass, and the consultory orders are lifted and is sworn in, we'll have let the people of Kenya down. They will not enjoy the provisions bestowed upon them by Article 10 Article 1 and Article 118. Article 118 creates and dictates that these individuals cannot be left out. Finally, my ladies, my lords, let us look at the question whether we have made out a case that deserves the granting of conservatory orders, and one that also deserves the dismissal of the applications by the respondent. My ladies, my lords, the National Assembly Hansons have been brought before you, and I will draw your attention to page 45 of the said Hansons. And most importantly is the submissions that were made by Honorable Millie Othiambo, the Member of Parliament of Suba North. At page 48, she makes observation that public participation had only two...
Do you have the Hansard as part of the affidavit?
Yeah, they have been filed.
They have been filed?
Yes, yes, my lady.
Where do we find them?
Is it part of the application?
It's part of the petition, my lords. That is 522, the Hansons.
Part of the application or part of the petition?
Petition.
Yes, then that is something different. We are dealing with the application.
But most importantly, my ladies, my lords, it went on Hansons that only 200,000 people purportedly participated in that process. That is to mean, my ladies, my lords, for Honorable Mutuse to have the guts and the audacity to move the motion, he had the backing of 200,000 people as against a population of 50 million Kenyans, or as against the population of over 14 million registered voters. What begs question for determination was that a qualitative and a quantitative public participation? Was it meritocracy? Does it deserve or could it convince that public participation that was adequate was conducted before the motion was moved? My ladies, my lords, to afford us an opportunity to bring this case out, we beseech you, my ladies, my lords, that you sustain and allow the conservatory orders sought and dismiss the application by the respondents. Finally, my ladies, my lords, I invite you to look at the submissions filed by the Attorney General in support of the application. Of most importance, my ladies, my lords, the Attorney General at page 6 of her submissions invites you to look at a conservatory order, sorry, not page 6, my ladies. That is page 5, as one that is meant to maintain the status quo. And she tells you, my ladies, my lords, that the status quo to be preserved is a status quo ante. That is to mean that the status quo that the court needs to preserve is the approval and the voting of Mr. Kindiki. That is, according to her, the status quo that she needs to be preserved. And she makes out a case that the conservatory order needs to be set aside so that that status quo can be sustained. There can never be anything that is far from the truth, my ladies, my lords. The orders of Justice Mwongo stayed each and every aspect that took place, including the implementation of the resolution by Parliament to consider the first petitioner as impeached. She further tells you in her submissions that conservatory orders are only capable of being granted under Article 23 of the Constitution. And she argues that Article 23 only relates to the Bill of Rights. And then she further argues that if the petition is not premised on violation or infringement or denial of a human right, then conservatory orders, according to her, are not capable of being granted by the court. But my ladies, my lords, we have put up a case that a right to a fair hearing was denied. We have put up a case that the Senate of the Republic of Kenya decided to abrogate Article 25 of the Constitution. If that is not a question that relates to a Bill of Rights, what then does it relate to? Further to that, my ladies, my lords, under Article 258 of the Constitution, to which we are saying that the Constitution has been abrogated and violated by the respondents, what remedy can the court issue in the circumstances that a case is brought out that the Constitution has been abrogated and violated by the respondents, if it's not a conservatory order? My ladies, my lords, finally, as I pen off, I invite you to look at the principles of public interest. It is in the public interest, my ladies, my lords, that these orders be sustained so that the Republic of Kenya can have the opportunity of the court pronouncing itself whether their democratically elected deputy president was justifiably removed and lawfully removed from office. That is to mean, your ladies, my lords, that under Article 38 of the Constitution, the people who supported the deputy president have a legitimate expectation. A legitimate expectation that their deputy president, as elected, will be subjected to a proper and accountable and transparent mechanism of removal. They also have a legitimate expectation that if any organ constituted by the Constitution does fail to abide by the dictates of the Constitution, that this court will uphold that position and that this court will set aside the impeachment. And the consequences of that, my ladies, my lords, is that if this court is convinced by our argument to set aside the impeachment, the question will then be that the deputy president will assume office. Number two, my ladies, my lords, you'll be urged to set aside the conservatory orders on the basis that there is constitutional crisis that is looming. But who has precipitated and created this constitutional crisis, if it does exist, if not the respondents? If they followed the law to the letter, and we feel satisfied that our client was justifiably removed from office, would not be before you, my ladies, my lords. We would have taken an ample pie and go home. But we are here before you, my ladies, my lords, because the situation has been precipitated and created by the respondents. Finally, my ladies, my lords, if the respondents are the ones who are at fault, do they deserve your mercy? What is the position of equity if they come to you with dirty hands? Do they deserve your mercy? He who comes to equity must come with clean hands. They are the transgressors and the violators of the Constitution. And therefore, my ladies, my lords, they cannot come before you as though they are saints. I so urge you, my ladies, my lords, to dismiss that application and uphold the application for the maintenance or for the retaining of the conservative